report of a processor might have flag X. Since it didn't appear on the last occasion, this honorable court was pleased to fix it today. It came up on 10/4/2025.
What is the report?
Flag X.
দেখা পাও মালিক লোক ধরি হইতে Have you seen the report?
Okay. The face of it is substantial. There are 3 positive orders in my favor, Your
No,
Lord.
that we are not on the contempt.
My Lord.
Prima facie, we are issuing notice. You are on the aspect of service of notice.
My Lord.
Because we have directed personal appearance.
Yes.
Now he did not find her in the house. It was found under lock and key. He got a telephone number, the process server, and connected her through telephone.
But 2, that is important. On the last occasion, I have kept copy. But I am going to file written objection for that.
Of the IA. Okay, IA is of 2022. When did you receive notice? Recently or what? Okay, we grant 2 weeks then. What about the paper book prepared or not?
Paper ready, Lordship.
Then we can have it for. Have you received a copy of the paper book? Huh? Have you received?
Oh, yeah, I received the only criminal appeal I received, but last occasion I received only IA.
No, that is okay. Now, are you insisting on the IA or are you ready to?
Insisting on the IA, Lord.
No, if the paper book is prepared,
Paper book is ready. You have received it, Lord.
No, we can have the entire appeal for hearing.
Lordship. Lord.
Instead of wasting your efforts in the IA,
Lord.
we'll direct furnishing of paper book to Learned Counsel for Respondent number 2. Madam, you have been served. Okay. What is your name?
D. Roy, on behalf of H. Hazarika.
Okay, heard Sri D. Roy, Learned Counsel, appearing on instruction of Sri T. H. Hazarika, Learned Counsel for the appellant. Also heard Miss A. Begum, Learned APP. Full stop. Sri, your name? NJ. On behalf of whom? Anath.
And actually, my name is not reflected in
No, your instruction
Yes,
of A to D or what?
Yes,
Oh, also heard. Also heard Sri N.J. Medhi, Learned Counsel, who has appeared on instructions of Dr. A to D, Learned Counsel for Respondent number 2. Full stop. Respondent number 2. Also, Sri Medhi has prayed for some time to file objection to the IA. Full stop. Para. We have, however, noticed that the paper book in the criminal appeal has been prepared, and the appeal being of the year 2022, instead of hearing the IA, the appeal itself can be heard. Full stop. The aforesaid proposition is also accepted by the learned counsel for the parties. Para? In view of the above, we direct furnishing of paper book to the learned counsel for the respondent number 2. And the appeal be listed for hearing when? In the 3rd week of May, 2025. Okay? 3rd week of May.
Much left.
You will be given a furnished a paper book. You contract the registry. Okay?
Much left.
Now we'll be hearing the appeal, not concentrating on the IA.
Item 6.
May I please, your lordship?
Yes.
Lordship, conducting counsel Mr. Tipipara is on lake, lordship, so matter will be taken up after some time.
After some time will be a difficult proposition. We'll have it when? Thursday? Okay. Madam, Thursday. A prayer for adjournment has been made on behalf of the appellant. Miss S.B. Chaudhary, learned counsel for the respondent is present. Para? In view of the above, list this appeal for hearing on. Tell us, date of your convenience. Thursday or any other date? Tell us.
24th, my.
Thursday.
It's Thursday.
Okay, it's Thursday. Okay, 24th.
Obliged, lord.
What is the appeal?
Lordship,
Understood. Who has filed the appeal?
husband,
Husband file.
Against what?
wife, lord.
Divorce, my lord.
divorce-
Divorce
Divorce
petition. was-
granted or not?
Granted, lord.
You are against the divorce. She had filed the divorce petition.
No, my lord.
Hmm.
Divorce petition was filed by the
It
husband, my
was
lord.
rejected.
Yes.
You should know the facts. Why don't you know the facts? What grounds did you file the divorce?
Lordship, actually, I was put in this case, lord.
What? That is not an answer. That is not an excuse. You have the file. You should know the facts. Basic facts. You should be interested to know the facts. Not the entire facts. Why the case was filed? What are the grounds? At least. Okay, come. Madam, what grounds?
My lord, according to the husband, my lord, my lord, the allegation is that the wife deserted him. But that
Desertion
is not
ground.
correct.
Desertion ground.
Yes. We
When
are
was the marriage conducted?
married in 2010. my lord.
And the divorce was filed when? So to the which year? See the judgment, see the cause title. Judgment dated in which year? Cause title of
2016, my lord.
2016, the suit was filed. Okay. And it has been rejected. Where are you staying now?
So,
No. Along with whom?
with her son, my lord, minor son, he's sick. My lord.
You are
He
living
stayed
separately.
alone, my
Okay. And
They're
where is the
rented.
husband staying?
husband staying, my lord. His hometown is Silchar and he's posted in somewhere in Delhi. He's in
Okay.
police department.
And what about maintenance?
Maintenance, he is paying only 7,000. So for maintenance, the petitioner, the wife has already filed a maintenance.
Okay.
It's
Okay.
going for enhance.
Okay. How many witnesses did they give?
My lord, it is not in the my notice date.
No. In the divorce.
Report.
You're also not prepared. Why is this? Okay, come
Well-
prepared on Thursday. Thursday, come prepared. Assist the court, otherwise difficult. 24th.
Item 7.
I have in fact seen it, but I'm appearing for the husband. The husband preferred the husband filed the that is put for resolution.
Just a minute, just a minute. AC to DDN. Mr. Barwa, you're for the other side.
Yes,
This is an appeal. Right, that probably the facts of the case, my lord. As per this honorable,
Madam, you'll be appearing.
that's what of this earlier on about that. We have raised this PW1 informant can be treated as an eyewitness,
Okay.
but
How many witnesses are there?
my lord, 17.
17. Yes.
Page 4, my lord.
Hmm.
The affair. Edit.
Sonali Begum and Sonali Bibi is the same person.
My lord,
Same.
Same.
PW1.
PW.
Okay.
Exit 1. Officer in charge, legal petition dated, but it is overriding method 17 October. It is well drafted. Affair. With due respect and humble submission before your good self, I have the honor to state that on dated 17 October 2012, at about 4:45 p.m. of out my husband named Nazrul Islam served under DSB unit Tirang district, who was coming towards our quarter after his duty. When he was come to the first corridor of building staff quarter, the accused thoroughly heavy constable number 139 Tirang district intentionally shot his arm to my husband. As a result of my husband sustained injuries on his that is past dorsey. On hearing boisterous blood, I rushed to the place of occurrence and have seen he was fell down on the corridor, and also at the time of death, though my husband told me accused Atwar shoot him with his duty arm. Thereafter, he expired on this. It is therefore prayed that your honor kindly investigate the matter and take necessary action against the accused person in due course.
Husband died.
Husband, no man.
Husband died.
Husband died. No man. He's our husband. Yes, our husband.
Oh, no.
Malan.
Then whose husband? How many husbands? are there?
Her husband. Her. It's this affair.
What is his name? Husband?
Husband, Malan. His husband.
Nazrul?
Nazrul is
Islam or what?
Islam.
What
Third.
is what has been written here? I-A-N.
Third. third line of the
And where is S? Nazrul, what?
NAZRUL.
Then,
NAZRUL.
then,
Islam. Well, Islam. In the well, bottom, well, wife of late Nazrul is
okay.
in her evidence, well, he admitted he do not know how to read English. In the affair, well, as per version, it is not written. As per her version, it is not.
Okay. She has lost the affair. Okay.
My on receipt of this affair, investigation was conducted.
The incident happened when? At about 6:45.
6:45.
What is the third line? What is the meaning?
My lord,
In the affair,
in the affair, my lord.
please
Third line,
please read again.
my lord.
With due respect and humble submission before your good self, I have the honor to state that on so and so of what? What is this autopsy?
Yes. Autopsy, my husband name,
Means?
my lord. And she admitted.
Yes, madam. What is this
Yes, but
autopsy?
no.
No. What is the meaning here?
Yeah.
And who drafted, who wrote this affair, the contents of the affair. Normally, every person we have seen as per version of the
Husband was also a constable.
husband was
And
both
the accused is also a constable.
constable, who reside in the same.
Think not that's only that find out the cause of death autopsy. Why it is in here autopsy of my husband name?
Well, normally, as a result, my husband sustained injuries
Then he
on his latimus
autopsy
dorsi, my lord. My lord, latimus dorsi is
That also
a,
is a very technical term.
my lord. So, lordship, as a result, my husband sustained injury on his latimus dorsi. Well,
What?
it is a latimus dorsi is a big tissue of the backside. So normally in the affair, my lord, a sustained grievance injury such and such. My lord, this is who wrote the type the affair, my lord. My lord, it is not mentioned in the book. My lord, latimus dorsi, my lord, he goes to some extent, my lord. On hearing boisterous blare, I rushed the place of
But she got caught on rust. Rust became rust.
Rashi Kamal. Are you?
There was rusting on the brain actually.
But the meaning of latimus dorsi is either a pair of a large, rough,
Understood.
triangular
But
muscle.
how do you describe in the affair?
That is
Will you describe a medical term?
the
Let me have time, either on the back or front or
Lower-
leg or arm or feet.
lower part of
Back that one.
the lower
And boisterous.
Boys.
Questions.
Boisterous blare. Then she rusted.
I put by the sorry man. It's not in the
Okay, let's proceed. No, it's not vernacular. It's typed. This is the original version. Had it been a translated copy, you would have understood.
Well.
It is the original version. And she has put her signature in vernacular.
Well,
SMEs.
she admitted, my lord, in her evidence, my lord, just one line. I do not know how to read English.
No, that is okay then. Okay.
I do not know
Okay,
who
let-
had written the exam.
Okay, doesn't matter. Ajahad is
Mal.
just the starting.
Mal.
We'll see her evidence.
Mal. PW1 Malat, page 8.
302 choices.
30. Page 8 of the paper.
Yes. PW1.
Yeah, Sonali. Page 20. 23rd court, 23rd of April 2015, madam. It's 3rd April. The incident took place around 6:45 p.m. on 17/10/2010. At the time of incident, my husband Nazrul Islam was posted at Adelgaon. He worked as SB branch. We live in a family quarter beside the SPO. We live on the 3rd floor. Accused Atwar Ali lived on the ground floor of the same. My husband used to come home in the evening every day, and just at that time, I used to come down and bring his shopping bag in advance. On the day of incident also, on seeing my husband stopping his motorcycle, I came downstairs. My husband was climbing up the staircase and I was climbing down. Just then accused Atwar came out with a carbine in a hand all of a sudden and shoot my husband from behind. I screamed as he shot him. I rushed to my husband and after holding him, I became unconscious. Accused Atwar ran to his quarters and closed the door. As soon as I got hold of my husband, he told me twice that Atwar had shot him. The bullet entered through my husband's back and exit through his chest. When I regained my consciousness, I learned that my husband had died. Then I lost the Ezahar. Exhibit 1 is the Ezahar, lost me. Exhibit 1 is Nasa. Affair was we had been living in that quarter for 1 year before the incident. Previously, we had lived in the quarter of 20 RBN at Panbari. The accused worked in the Department of Police. I do not know what was his designation. Earlier, he had not had any antique acquaintance or visiting terms with my family. The building of our quarter had 4 stories. There were 4 quarters on the ground floor. A staircase on the one side of the 4 quarters. I do not know who were there in those 4 quarters, but there was the people there. There were no other houses or quarters near our 4-story building. The staircase was adjacent to other quarter. There were people in the nearby quarter. I know them, but I do not know their name. It is not a fact that I did not state it before the police that while I was climbing down the staircase, I witnesses Atwar shooting my husband from behind. This IO has been confirmed. I am coming. My husband did the work of the police verification SB branch. There was no weapon with him. All the residents in the quarter were police personnel. I do not know if all of them had arms with them. There was a light in the staircase. It is not a fact that accused did not shoot my husband. We had no quarrel with Atwar. I do not remember now for how long I remain unconscious. If at one moment I regain my consciousness, next moment I lost my consciousness. It is not a fact that my husband did not say that Atwar had shooting. It is also the other evidence, my lord. When I screamed, the resident of the other quarters came, but I was not in a state to see who came or how many people came. I cannot say how many people heard my husband uttering that Atwar had shot. It is not a fact that Atwar had not killed my husband. It is not a fact that some other Polish personnel had killed my husband. I do not know how to read English. I do not know who had written the Ezhar. It is not a fact that Ezhar was written, not written as per my version, or I was not read over the content of the same. From this, it is not the disease reside in third floor as per her. I reside in the first. Just time again. I used to come down and bring his shopping bags on the day of the incident. Also, on seeing my husband stopping his motorcycle from the third floor, he was saying that motor stop. I came down. My husband was climbing upstairs. A lot. Normally in the staircase from third floor to ground floor, because of the construction system, it cannot be possible for a human being whoever comes from that. Why I'm arguing this matter? It is confirmed by the other because he was not present at that what I said. And I was climbing down. Just then accused Atwar came out with a carbine in hand, all of a sudden, and shoot my husband from the third floor, from the first floor. I came out from the my quarter, the carbine. It is not a possible of a human being. Now I take a lordship, my lord. My lord, he rushes the after. He says in the affair, my lord, that is dead.
Where is your sketch map?
My lord. Case map at my lord 115. Lord, got it.
115.
115. A indicates page 16. A indicates the place of occurrence where there is a pool of blood. That your lordship see there in the front of the A mark. Round, my lord, it's blackish. Hold. Now B indicates blood stain at the place of occurrence.
Yes.
Just C indicates the hole on the wall in the upstairs of the building caused by bullet. D indicates the staircase which lead to the upper floor. E indicates the official quarter of the ABC at 139 upper. Well, this is E. So therefore, from the third floor, for a human being, it is not. G indicate F indicates the official quarter of UBC Deepak Kumar Pai. I am coming regarding Deepak later. G indicates the official quarter of UB is Dharmendra Nartari. H indicates the official quarter of the Abhiram Roy. For all are 4 quarter. I indicates corridor of the ground floor. And J indicates electric light. Now, just I'm reading the 16 mallet because I read PW1. Now 16. The IO. Mallet, page 45.
Well, let us go serially. We'll come to the contradiction part. The contradiction, if any, you can point it out later.
Mallet, Caesar list. Mallet, Caesar witness mallet, PW5.
No. Let us go serially.
Serial, mallet. Then mallet, page 11 mallet. PW2 matter, Shah Jalal Sheikh. I know the accused actually. He was the AB constable posted at Police Reserve, Tirap. DSB Constable Nazrul Islam was known to me. He was residing at second floor of the 4 State quarter at Shantipara. Now, he stated, I reside in the second. This is as per PW1 and it's a contract with his family. I used to reside in the same building at the second floor, whereas the accused person resided at the ground floor. On 17/10/2012, the occurrence took place. It was about 6:30, 6:45. I was returning to my quarter after the duty hour. When I was about a distance of 670 meters away from the quarter, I saw Nazrul Islam to get down from his bike. He parked the same in the corridor and thereafter proceed to the staircase for going to his quarter. He had a bag in his hand. Immediately after that, I saw accused to come down in the corridor with carbine in his hand. After 2-3 seconds, I heard the sound of a firing. Immediately, he heard her. I sat down on the road, but heard the scream of the wife of the Nazrul Islam. I rushed to the quarter. On going there, I found that the wife of Nazrul Islam had arrived there by his time and she was holding Nazrul Islam. I saw the bullet injury at his back. He was alive till then. He asked for water. On a question by his wife, Nazrul somehow managed to say name of the Atwar and also had shown the door of the Atwar pointing his finger. He was lying at the first tier near the quarter of Atwar. The door of the Atwar was closed from inside. In the meantime, UBC Deepak Roy and UBC Moinul Haq arrived there. There was a hue and cry. People rushed there. Women also came out from other quarter. Thereafter, we took the victim our departmental vehicle to Maharashtra hospital. Doctor declared him dead. Dead body was sent to the thereafter came to the that's all.
Yes.
I have been serving for long 14-15 years. At the time of occurrence, I was serving as UBC. Some UBC constable get armed, some do not. AB constable get armed. After the duty, we surrender our arms and magazine to the charge of arms. I came to the quarter 1 year before the occurrence. The distance of the police reserve from the quarter was about 250 to 300 meters. On the date of occurrence, I performed the duty till 6:30 p.m. After that, I came out for going to the quarter. I was on foot. I take 5-7 minutes to come to the quarter from police. I used to reside with my family in the second floor. This floor has 4 quarters. I did not see the firing. It is not a fact that I did not state it to the IO that I saw Nazrul from a distance of 60-70 meters. Well, I am coming to the IO slip. It is also not a fact that I saw accused Atwar Ali to come out with a carbine in his hand. It is not a fact that I did not state to the police that victim Nazrul told his wife that accused Atwar fired the shot at him. I arrived at the spot within 1 minute of the gunshot. Hearing the cry, I rushed to the place of occurrence. I did not state to the police that immediately after hearing the sound of gunshot, I sat down on the. It is not a fact that, but in the inner evidence, he says, it is not a fact that I did not state to police that I saw gunshot injury at the back of the Nazrul Islam. I saw 8 and 10 persons together there. Amongst them, I saw Deepak, his family, wife of Bhakta Bahadur, wife of Anil Pradhan, Mainul, his wife, Dharmendra Narjari. We knocked the door of Atwar, but he did not break open the same. We immediately rushed to hospital. We did not inform the police. In front of the quarter, no other member was no number was pasted, but in the quarter sheet there was marked. In the adjacent left of the staircase, the quarter of the Atwar, and in the adjacent right of the said staircase, the quarter of Dharmendra Narjari were there. It is not a fact that accused were never stayed in the quarter. In the ground floor, Babul Basumati and Deepak Roy were also staying. It is not a fact that accused Atwar Ali was on duty at the relevant point of time. It is not a fact that accused Atwar did not commit the murder of Nazrul. I did not see the empty cartridge of the carbine in or around the place. On the day of the occurrence, one quarter at the top floor was vacant. There is only one staircase at the building. It is not a fact that I did not see anything, any occurrence and depot. But I did not see the empty cartridge of the car. Ballistic report and the others with the written. PW3, and this his evidence also contradicted by I and other 7 and 9. PW. Now take a look. PW.
Yes.
Mainul Haq, so above whom the PW listed. I know accused Atwar Ali. He was baby constable. This is Nazrul Islam was DSP constable. I myself has been residing in the 4-story building of the police quarter. Here, that Atwar Ali was residing in the ground floor of the said building, whereas Nazrul Islam was residing in the second floor. PW1 say he is stated on 17/10/12 at about 6:45. The occurrence took place. On the day of occurrence, myself along with my wife and my son went to the Bamaingao for marketing. We came back to the quarter at about 6:30 p.m. My wife immediately went upstairs. While I was parking my bike, my son went to the stair to the quarter of Atwar. He knocked the door and also called the son of Atwar. Atwar himself came out. 6:30 came out. He was wearing a black pant and check shirt. He had a carbine with him. He told my son that his son was bleeding and could not come. Then I myself and my son went upstairs to my quarter. After 10-15 meters, I heard the sound. Minutes minute actually. 10-15 minutes. I heard the sound, and at first I thought that it was a sound of cracker, but immediately I heard the scream of the wife of the Nazrul Islam. She rushed downstairs. Then I too came out going downstairs. I saw Nazrul Islam in the injured condition. Wife of the Nazrul was holding him. He was still alive. On our query, he told us that accused Atwar had fired him, and he pointed out the quarter. He was lying at the foot of the staircase near the quarter of the Atwar. By that time, hearing the hue and cry, people gathered. some of the women started knocking the door of the Atwar. I asked them not to do that. Thereafter, on seeing the critical condition of Nazrul, we decided to take him first to hospital. Accordingly, we took Nazrul in our departmental vehicle. The doctor declared him dead. Thereafter, body was sent to Morgan. After that, I passed him there, and I was posted at Roumari OP, but the OC Khaligaon PS attached me at law and order duty at PS on the day of the occurrence. I had duty till 2 p.m. In our building, 1 quarter was vacant and the remaining 15 quarters allotted to 40%. The quarters number was not there. Quarters allotted to Deepak Roy was adjacent to Atwar Ali. Quarter of the Dharmeshwar Nardari was in front of the Atwar Ali. Quarter of the Babul Mashratari was in front of the Deepak Roy. On the day of the occurrence, Deepak Roy was there, but I did not notice Dharmendra Nardari. Babul Basumatri was not. It is not a fact that I did not stated to police that I saw a carbine with. It is not a fact that I did not stated to police that after coming back from market, my son directly went to the quarter of the knocked the door and also called his son. Hearing the scream, I came out and followed the wife of the Nazrul Islam. After getting down, I saw wife of Nazrul Islam and Shahjalal Sheikh. After 10-15 meters, other resident of the building, I cannot name them. It is not a fact that I did not stated to police that Nazrul told us that accused Atwar had fired at him. It is not a fact that Nazrul did not point out the quarter of the Atwar, nor he was in a position to point out. I cannot say exactly after how many minutes of the hearing, the sound of gunshot, I came down. I did not notice any empty cartridge. The situation was not just to see all this. When Nazrul pointed out his finger, his wife was there. I cannot remember whether any other person was. It is not a fact that the accused Atwar was not in the quarter. On that day, I did not see the carbine with him. It is not a fact that I did. It is admitted by the, I cannot say exactly how many minutes hearing the gunshot.
But the dying declaration suggestion was negated by him.
Yes, well, I negative.
No, the suggestion was given to him that you did not state before the police.
Yeah.
He had negated the suggestion. He said that I had in fact said before the police.
But that is, but in the it was not confirmed by the IO because he did not state it. That pointing out or that other 7 and 9 will have. All of this witness PW4 matter Dharmendra Nardar because of the illness further because of the illness further his cross was expanded discharge.
Whose?
PW4 need not be it. Well, even the night, the day of the this is accused Nolu was ST. I know accused authority, Deepak Roy, and I stay on the ground floor of the 4 building. I stay indoor as I am a sick person.
No, not required.
Not
relevant.
Well, that is not. Now, PW5 Miller, Caesar witness. That on 17/10/12, I was working as API at it. I was the inspector of the armed branch. On the day of occurrence, I was in my quarter behind SP Banglo. at about 7:30 p.m., I received a phone call informing that there was a firing at the family quarter of the police. Immediately, I rushed to the place of occurrence. The place of occurrence at the ground floor of the four-story family quarter. There was a large crowd, and I noticed blood stain near the stair. I heard that accused actually had opened fire at DSP Constable. The body had already been removed to lower court hospital. Atwar was also not there. Thereafter, police arrived. During search at the place of occurrence, one empty case of the 9 mm ammunition and fire were found at the place of occurrence. Police seized the 9 mm empty case. White exhibit 21 is my signature. The fire bullet was also seized, and I put my signature as Caesar. Yes. Exhibit 3 is the Caesar list, and exhibit 3.1 is my signature. Police also searched the quarter of the Akbar Ali and found the 9 mm carbine with one magazine. Two other magazines were found in the VIP. Total 70 rounds of ammunition were issued to the accused and one round was found shot. Police seized the same, that is carbine, magazine, and 69 rounds of ammunition in my possession. But exhibit 4.1 is. After a few days, police also seized the armed ammunition issue register from our Malkhana magazine court and gave it a zimma of mine. Exhibit 5 is the seized Caesar list, and exhibit 5.1 is my. The register has been bought today. Material exhibit 1 is the Caesar carbine with body number 16086-108. Material exhibit 2, 3, and 4 are the 3 magazines. Material exhibit 5 are the 69 numbers of 9 mm ammunition. And material exhibit 6 is the magazine pouch. Material exhibit 7 is the hard plastic body suitcase. Name of the accused was mentioned there. Material exhibit 8 is the fired bullet, and material exhibit 9 is the empty case of the 9 mm ammunition. Material exhibit 10 is the arms and ammunition issued. It is the register of issuance of carbine. Material exhibit 10 is the photocopy of the agreement, and exhibit 10(2) is the photocopy of the.
Yes.
Cross. Distance of the place of occurrence from my quarter is about 400. I cannot say who had informed me over. I used to visit the family quarter time to time. I saw 20-25 persons were on my arrival. In the said quarter, there were 16 families. I could not recollect the name of the Shoilen Roy and Deepak Roy. I cannot say the quarter number of the Atwarali, but it was in the ground. I cannot recollect the name of the occupants of the road. I entered the quarter of Atwarali along with the OC Dalicom PS, DSP HQ and Caesar list were prepared probably at the police station. Why I cannot recollect. I saw ammunitions recovered and counted the set. In none of the Caesar list, signature of Atwarali was written. In exhibit 2, 3, 4, 5, the quarter numbers of the Atwarali not the 2, 3 is called the empty case ammunition. In a carbine magazine, there can be up to 34 ammunition. Each ammunition contain manufacturing number. In exhibit 3, the number of the bullets were not mentioned and only 9 mm bullet is present. Material exhibit 5, that is the ammunitions are not in seal pack. In material exhibit 10-2, the body of the carbine mentioned is mentioned 16086-106. But when in the chief ballot, it is 8. It was discussed when we have taken a difference. There is overwriting on the last number 6. In the material exhibit 10, the counter sign of the inchard is not taken. That is why, my lord, in the between, my lord, earlier occasion with this honorable court person being that register the R part. They are not perhaps only the person to whom the arms and ammunition were issued put his signature. It is not a fact that material exhibit number 1 was not issued to Atwaran. It is not a fact that seized items were not recovered from the quarter of the Atwaran. It is not a fact that material exhibit 10 was subsequently manufactured. It is not a fact that I do not know anything else. Then PW6. Jai Prakash. The incident took place on 17/10/2012 near our police reserve family line. The incident took place around 6:07 p.m. At the time of incident, I was working at the office of SP Chira. Take 5 minutes from the SP office to the place of occurrence. Someone came to the office and informed that an incident of the firing had taken place about line. On receiving the news, we went to the place of occurrence. Reaching the place of occurrence, I saw that our SI Onil Das, DSP sir, and the AABI Sabit Ali were already present there. I heard the constable then another constable Nazrul. The quarters of the family line, the 4-story building. The incident took place in the staircase that contained the ground floor with the first floor. I saw blood in the staircase. Accused Aswar room was adjacent to the place of the occurrence. His room was closed from outside. When we knocked the door, his wife went. We all entered the room in the search of weapon. Then we found a carbine inside the carbine after a bed and a 2 magazine and some loose round in a suitcase. Taking the carbine, we find 19 rounds of bullets in the magazine attached, and there are 20 rounds of bullets in the 2 magazines which were in. We also found 10 loose rounds of bullets. Then these articles were seized. I was saying that the list exhibit 4 is the list and exhibit 4 there. Material exhibit 1 to 7 are the Caesar carbine, magazine, and 10 rounds of 10 mm 4 ammunition And when we were sure that the accused was the one who had fired the shot, we made a search of the empty cartridge and we found the same at the place of the occurrence. The empty case was seized. I provided the same in the scissor list. Exhibit 2 is the said scissor list and exhibit 2 is that's there. Material exhibit is the empty case. We saw a mark of firing on the wall of the place of the occurrence. When the DSP told us to search the bullet, we did so, but found a fire bullet at the place of the said fire bullet was this. I my signature in the list. Exhibit 3 is the cell list. Exhibit 3 and exhibit 8 is the said fire. At the time of incident, I was in the SP office. I went to the place of occurrence at 8 p.m. Beside our officer, there were 10-15 people present at the place of occurrence. I do not know their name. I do not reside in the quarter at the place of occurrence. There are 4 quarters on the ground floor of the building at the place of the occurrence. There were quarters allotted in the name of the accused for Constable Deepak Roy on the ground floor. There were 2 other persons in whose names quarters allotted the ground floor. Why I do not know their name. Constable Deepak Roy's quarter was in front of the floor. I do not remember it now whether I, while making a statement before the police, stated that I had met SI Onil Das, DSP sir, and API Sabedar at the place of the court. And that when the door was knocked, Akbar's wife opened. SI Onil Das, DSP sir, AP Sabed Ali, and another constable. And I entered inside the house of the constable. I do not remember the name of the constable now. It is not a fact that there was no quarter allotted in the name of the Akbar at the place of occurrence. It is not a fact that the seized article were not recovered from the Akbar group. It is not a fact that I did not state before the police that empty case was recovered in front of the Akbar house. Exhibit 2, 3, and 4 were prepared at the place of occurrence. At the time of incident, I was not present at the place. It is not a fact that exhibit 2, 3, exhibit 4 were prepared at the place of the occurrence. Rather, those were prepared at the. This evidence is contradicted by the evidence of the PW5. They cannot assure that whether it was prepared at the police station, probably prepared at the system. Now, PW7.
The signing of the scissor list at the police station
Right.
is one aspect, but he says that he was present
Mala,
while
that-
the scissor was made. The formal scissor list, if the scissor is done, if his presence has been deposed, that I was present when the scissor was made. His signing at the police station will not make much of a difference.
my lord, but
We find cases where scissor has been made separately and they are made to sign in the police station.
But-
That may be fatal. But here is only the formality was done, the signing part.
my lord, signing part. But,
But he
PW
says that page 26, when we knocked the door, middle part,
Right.
his wife opened it. We all entered the room in search of weapon. Then we found a carbine inside the carton under a bed and 2 magazines and some loose rounds in a suitcase. Checking the carbine, we found 19 rounds attached to it and there was 20 rounds of bullet each, or 2, which we also found 10 loose bullets.
now, page 23, scissor list were prepared, no, not signing. Scissor list were preparing of list and signing. Two different things, maybe my lord, but scissor list were prepared probably at the police.
Oh, doesn't make difference. If his statement was not there, that he was not present at the time of seizure, you could have had a ground that you cannot be a seizure witness at the police station. He was a witness. The signing part, preparation part, he had done at this.
I understood. But
That-
scissor
that-
prepared at the police. But where is the question of signing at the place of the occurrence by the PW6?
PW6 says that he was there at the time of seizure. Normally, what happens at the cross-examination, some unknown persons there meet seizure witness. Where have you signed? I have signed in a police station. That means says that he was not. But here in the chief, both the PW 6 and PW 5 has said that they were present while the seizure was being made.
They are present. But seizure list are prepared at the
How do you
Well-
overcome the dying declaration?
I'm that part. Now PW 7, Srimati Mitali Roy, that Deepak Kumar Roy husband, he also. I know the informant Sonali Begum. I also knew her husband, that Nazrul Islam. My husband uses to do service in the police department of Assam. Occurrence took place on 17/10. At that time, I, along with my husband, resided at Chirang police station. The quarter of the Chirang police reserve are located in a four-story building. We reside in a quarter located at ground floor. This is Nazrul Islam with his family also reside in a quarter of Chirang police reserve, which was located at the third floor of the building. I know the accused standing in the dock. His name is Atwar, and he is also served in the police department at the time of occurrence. He also reside in a quarter in the ground floor, which is next to my quarter on the eastern direction. Occurrence took place around evening 6:30 o'clock. At that time, I was present in my own quarter, and my husband returned the quarter after doing his duty, and we were taking tea. Just then we heard the sound of gunshot, and after a few seconds, I could hear crying raised by some women. I came out from my quarter by opening the door. I saw that on the stair of the ground floor, informant Sonali Begum was crying by holding her husband Nazrul on her lap, and Nazrul was seen with a pool of blood. I saw Sonali asking her husband to the person who did the said act. Then Nazrul could not say anything but point his finger towards the residential part. The disease could not point. In meantime, many people assembled there. Thereafter, my husband, along with police Moinul Haq, Shahjalal Sheikh, arranged the police vehicle and shifted the injured to Bhaiga Hospital. At some point, I came to in connection with the case and gave my statement. Well, taking water by the other say. At the time of occurrence, my husband used to work in the computer section of the CIOP. The quarter number of my residential quarter was 1. There were 4 quarters at the ground floor. I cannot say exactly who reside in other quarters located at the ground floor. The said forested building are consisted with altogether 16 quarters. I cannot say how many families reside there. I knew them but cannot say their names. After hearing the noise of gunshot, I came out from my quarter after 2-3 minutes. At that time, I, along with my 3 minor children and my husband, were present in this quarter. I did not see the occurrence. At the inhabitants of those quarters are police personnel, and all of them having arms. When I came out from our quarter, all the inhabitants of the building came out, and I saw 15 to 20 number assembled there. Amongst them, Deep Roy, Pinky Roy, etc. came. I have not asked anything to the deceased. It is not a fact. Sonali did ask her husband to the person who did the said acts, and Nazrul did not point his finger towards the residential side. And I stated false. Except blood, I have not seen any empty cartridge lying in the at the place of the. It is not a fact. Today I have friendly term. And he stated that he had not seen it. Now, PW 8 Zakir. On last 17/10/2012, I was serving as Havilдар at Police Reserve, Tirang district. On that day, I was on the duty of the office at about 4:60 p.m. While I was on the duty at the office, just then heard the sound of the gunfire at the family quarter of the Police Reserve, which is nearby the office. Hearing noise of gunfire, I went near the family quarters of the Police Reserve to find out the source. Then arrived in front of the quarter of the accused, saw blood stain on the first floor just below the step of the quarter. I also heard the gathering people acoustically fired a DSP Constable Nazrul Islam, who stayed at the same building. I did not find Nazrul, and in the meantime, he was shifted to the hospital. Subsequently, police appeared at the spot. Police recovered one 9 mm empty cartridge and fired cartridge while lying at the spot, with the police preparing that represented by which the 9 mm empty cartridge. I put my signature wherein the white exhibit and white exhibit. The IOC is the recover contained. I put my signature in the exhibit. It also charged the by authority. Number 3 of the magazine, 69 9 mm live. Although they have seen seized empty case and fire bullet in court. Material exhibit 9 is the same empty case and 8 is the fire knife. Fire. Today, accused actually is standing in the dock. I have no residential quarter at the family quarter of the police station. I never visited the house of police. I arrived at the spot after 15 minutes hearing the noise of gunshot. I came alone on the spot. I saw many people gathering there and they were all personnel. I did not see any civilians there. Around 10-15 police personnel gathered at the spot. I have not seen the occurrence with my own eyes. It is not a fact that I have not stated for IOC that I saw blood stain on the floor, just below the step of the water. I cannot say that. It is not a fact that Caesar list that Caesar pellet fire bullet was found lying on the stair of the ground floor to first floor of the 4-story building of the police. I cannot say how many persons injured in the I have counted 69 numbers of 9 mm live ammunition, also plus the magazine which were found from the. I entered in the quarter of and counted those the quarter. I cannot exactly say in whose name the quarter was adjacent to the authority. That occurrence, date of occurrence, I did not. I did not then PW9 is the husband of PW7. Occurrence took place 7/10/12 at about occurrence took place at the Chirag police. That time he was I know the accused was also knowing as constable. I reached the police reserve at 16 after meeting by at that time I was my home. Then I heard a sound of firing. After some time I heard someone crying. After hearing even crying, I had my wife went out. I saw this is Nazrul Islam was lying in the injured. I saw bullet on his chest. He pointed out the quarter of the door of the quarter blocked from inside. I called authority, but no response found. I informed PSI Nazrul Hussain through telephone. The neighbors came to the spot. I with Jamaluddin Sheikh Shah Sheikh Hussain and Abdul Haq I came out after 5 to 7 minutes later from the time of firing. My quarter was in front of the station. In between my quarter and the quarter of quarter, there was a staircase. My quarter was number was 1 and the quarter number of There was 4 quarters in the ground floor. Beside us, one Havildar and Abul Masumatari was also beside. I did not see the occurrence. 15 to 20% gathered there. Abul Masumatari, Havildar, Soilen Roy, Hogan Roy, Jamaluddin Sheikh, Roy, Rosary present. For information, speak anything. I could not ask anything. I took the injured to the hospital after half an hour. It is not a fact that I stated that the accused pointed out. The accused was working as ground plan constable. I could not say whether he was posted at that that I have.
Yes.
Then whether medical officer, it would get Dr. Meenakshi. On 18/10/12, I was working as medical health officer in Moyna section. On that day, I contacted got from the lower Assam hospital, Moyna CPT, CT, and 18/10 on being produced and scored by 634 Fazlul Islam and also identified the external appearance, the healthy male of the average build patient with small wound present at the back side, left side, size about 2 centimeter by margin, hearted, paired with suggest wound of but a small wound present above right nipple, everted margin, size 2.5 by 2.5, exit wound 3, a throw and throw small wound present at the right side or the right tear present in upper part of the right part, operating injuries in the upper part of the right lobe and for diaphragm wound is with blood. Then opinion. In my opinion, the case of the death is embarrassed and shocked causing bullet explicit I conducted the I mentioned left side of back, but not mentioned lower part the or up part. That is the input.
Next is the wife,
Wife of the
declared hostile.
mother. And it
Yes, you can read. Okay. Huh? About यार क्या? Already बोल.
Detective,
Huh?
police check, but okay.
You have to remove the bombs from the mind of the people. That is more dangerous than a physical bomb.
that is true.
Let police do their part. Let us do our duty.
Anil Rashid corrective, we have to remove bombing from our mind.
So yes. Parking panic. Do you see any panic in the court? We don't see any panic. in the court.
We are inside the court.
And immediately JD Vance is also there. Yes.
I know the informant. Accused is my husband. I know the deceased was the husband of the informant. Occurrence took place about 6-7 years ago at Bristol. At that time, I, along with my family, was residing in our official quarter, which was a 3-story building. I heard about 8 p.m. At that time, I was residing with my husband and 3 children. I was busy with the study of my children. I taught them at that time. My husband was also staying in our home at that time. I heard that one Nazrul Islam police personnel died. He died due to bullet injury. Police interrogated that matter crossed by the public. It is not a fact that I stated before the IU court that on the date of the occurrence, there was a quarrel between me and my husband, for which in the evening, I, after closing the door of the inner room, taught my children. At that time, my husband was viewing the TV in front of. Suddenly, I heard a sound of firing. Immediately after the sound, my husband gave blow upon the door and opened it, and my husband immediately kept his arm. Other ma-
Just a minute.
Immediately after that, the sound my husband gave blow up, and I opened it, and my husband immediately kept his arm by the out other side. After that, he fled away through the back door, and at that time, 6. It is not a fact that I stated before Dario. At that time, my husband was wearing black pant and shirt. Investigation officer visited at quarter night. Police seized the arm and ammunition kept under my bed.
Yes.
Those articles were seized by the IO before I put my signature up. Is the signature before she is my signature.
Caesar witness.
There was no enmity between suggestion as it was there was no enmity between me and investigation, so that they wrote some false statement. In this case, my husband was arrested and yes, I have not received any summons. Please did not record statement. I put my signature on blank paper. There was no any prior enmity between my husband.
Why this answer that I had not put signature in blank paper?
that is মানে কোথায় ঘর
Hmm?
মানে that is like
You are
that.
not supposed to sign a 161 statement. Advice was not properly done.
Police did not record my statement. I put my signature on a
See,
blank.
till not recording the statement is okay because
Well,
he had denied
well.
that you had made a statement before the police. No, I have not made.
Well.
They have made a statement I have not made.
Well.
And did police record? And police never recorded. Then she thought
Question is,
that then my
ten
signature might appear somewhere. So my
Mala.
signature was put on a blank paper.
that is reverse, man. That is. Mala, police did not record my statement. After that, there is finished, man. Man, I put my signature on a blank paper.
Now we'll just discuss with my sister that we'll examine the statement of the deposition of the IO.
Mala.
IO is immediately coming, PW 12.
16.
No, next. IO is
No,
PW.
that, Mala, no, this, he also IO, Mala, but only part of the Mala.
Charge sheet part. Okay.
The sheet part is the 16.
No, who had done the investigation?
Mala, major part is 16.
16.
Mala.
What is 12 then?
12, my lord, that is the common certificate, other things. Well, just only 12 is required needed.
Okay.
13, 14, 15 is not required.
Okay. Now let us read.
Well, Khoghendra Chandra Roy, on 16/1/13, I was serving as second officer of Dhaligaon Police Station. On that day, OC Dhaligaon Police Station handed over the case diary of Dhaligaon PS case number. After taking the charge of the investigation on 23/3/13, I seized common certificate issued on 6/10/12 in the name of the act. That is the common certificate in respect of the Mala that happened.
What is the common certificate?
Mala, in respect of that command Mala.
Oh, that he has seized this.
Mala.
Seized. Okay. We thought he was issued.
Mala.
Okay.
The common certificate was given to the accused of ASI Vishnu Devta. On 22/4/13, I seized the issuing register of arm and ammunition. The said register was given to the custody of ABI Sabed Ali. I recorded the statement of witnesses, namely AB Sabed Ali and Constable Purna Chandra Nath, Police Reserve Sheriff. Only he is not examined. ASI Vishnu Devta. All are not examined. Sushil Chandra Biswas. After that, I was transferred, for which I handed over the case diary to the concerned OC. Exhibit 5 is the seizure list by which armed issue register was seized. Exhibit 5.2 is my signature. Exhibit 7 is my seizure list by which common certificate was issued. Exhibit 7.1 is my then cross method. It was not mentioned in my seizure list from the which branch of the police reserve common certificate was issued and who issued the common certificate and issue number. In Exhibit 5, volume number of the register, who issued the register and period for which the register was issued were not. That is why, madam, in respect of the discrepancy of the number of the carbine. So it was discussed in the judgment, madam. That is why the idea of both. Though it is in a part of the record also, but although 13, 14, 15, this I time to time not matters. But 15 mallet, I know the accused as well as this.
No, what statement was recorded? Accused statement means?
13
161 statement or what? What
Mala.
accused statement?
accused.
Okay. He's also done the investigation for some point of time.
At some point. 14 also same man. Now 15 man. It's called. I know the accused as well as deceased, but I do not know the informant. On 16/10/12, I was serving as ASI Police Dhaligaon, Tirang Reserve Police. On that day, at about 10:45 AM, I issued a duty command to accused. He received the command police reserve. After that, he left the police reserve. After that, on 17/10/12, within the same alignment, I got the information over telephone. Accused shot dead, one of the victim with that cross. Exhibit 9 is the common certificate book. Exhibit 9 was the duplicate copy of the common certificate. The original common certificate was given to the accused who received the same duly. Exhibit 292 is the signature. Signature is the accused. The document is the- Exhibit 10 is the duty slip issued to the armed branch. Inspector Sabed Ali is the signature of the Inspector Sabed Ali in accordance with the signature. Now crossed by the defense matter. In Exhibit 9, duty slip are attached in the sum of the certificate and it was not attached in the other. There is not serial number in the duty slip. It is not a fact that Exhibit 10 was not issued by Sabed Ali and it was prepared subsequent. Exhibit 9.1 is at the time of return, it is not mentioned. Exhibit 9 is the carbon copy and 9.1 is not written as duplicate copy.
Now you come to 16 hour.
16. Now he succeeded at that's why we are 60.
No, charge sheet was submitted by 14.
14.
14.
14.
Okay. Come to 16 now.
Well.
15 is also issuing common duty.
Right. On 17/10/2012, I was serving as SI of police at 30 PS. On that day, I was in charge of police station. On that day, about 6:50 p.m., I was at Banglagaon in the railway track, checking and general patrolling duty. Then TSI Nazrul Hussain informed over phone that one AB constable Atwar was hurt by shoot upon another DSP constable Nazrul Islam who sustained grievous injury. The shooting was happened in the family quarter of the Kazirgaon police reserve. After getting the information, TSI Nazrul Hussain made Dhaligaon police station DTNT number 6 and proceed to the place of occurrence. After getting the information from TS Nazrul Islam, I also proceed to the place of occurrence. I reached place of occurrence at about 7:12 p.m. In the meantime, the SP, additional SP were also present at place of occurrence. Place of occurrence is a corridor in front of the house of the Atwar Ali. I drew escape map of the PO prior to my reaching. Some constable took the injured person to the hospital. I seized one empty case of 9mm ammunition, one 9mm carbine registration number 16086-108 with one ceiling, one magazine fitting with 19 rounds 9mm ball ammunition, two numbers of ammunition carbine magazine loaded with 20 round of 9mm ball ammunition. In each magazine found a VIP bag kept inside the room of the accused person. 10 numbers of 9mm ball ammunition package, plastic carry bag which was kept inside the VIP, one old VIP bag 6 inches Sony company having name of it, one pellet fire bullet of 9mm, empty case and fire bullet were found in the corridor, the place of occurrence, and the other ammunition were found in the court. I did not find the accused because he fled away after the committing of. I record the statement of the witnesses at place of occurrence. In the meantime, affair was lost and the concerned OC entrusted me for investigation. I sent the arms and ammunition for forensic laboratory, Kahalipara. When injured Nazrul Islam was taken to the hospital, he was declared dead by. Exhibit 2, 3, 4 are the serial list by which arms and ammunition were seized by me. Exhibit 2, 4, 2, 3, 4, and 4, 4 are signature. Today I have seen all the seen arms and ammunition before the Exhibit 11 is the extract copy of the Dhaligam PCT number is by signature, 12 is sketch map, 12 annexed. When I reached the place of occurrence, I saw there was a sign of firing on the wall of in corridor, which was a common place. I also found blood sustained at the step towards the house of the deceased Nazrul and his doorstep. I took several attempts to arrest the accused, but I could not find. Battle Exhibit 1 is the weapon of the offense. I found it on the bed of the wife. The accused was present in the house of the accused at the time of occurrence. After that, I handed over the case diary to the concerned as I was transferred. PW 11 stated before.
Who is 11?
Well.
Wife.
Well.
Yes.
That was in the subsequent denied. Where it well already you have that on that day of the occurrence there was
Not
a
required, not required. This is
Well,
only a verbal.
already
Oh.
Now cross. When I reached the place of occurrence and found about 15 persons there, the quarter belonged to a deceased was in the first floor. I visited his quarter. I did not find blood stain from the step up the quarter of the. There are 4 quarters at the ground floor. There was a staircase between 2 quarters each side. In the northern side of the place of occurrence, there was a corral, a quarter of the UB and HG Dharmendra Nursery. In the northern side of the place of occurrence, there was a quarter of the UPC of Briham Hall. I did not search the quarter of this. They are also police personnel. There was no arms and ammunition along with them because they were unarmed. The entire building was 4-story building. I did not search other floor of the building. I did not investigation who reside in other. In Exhibit 2, Exhibit 3, Exhibit 4, I have not mentioned the quarter number of the accused because there was no quarter. It is not a fact that there was a quarter number for each quarter. I did not specifically mention the quarter in which direction yours stand in my scissor. It is not a fact that carbine being registration number 16086-108 was not issued the Exhibit 10. PW6 did not state before me that empty case was seized, which was lying in front of the house of the. But he stated before that same was lying at the place of to the place of occurrence in front of the quarter of the act. PW1, basically PW1, 2, and 3 of the basing of their evidence method. PW1 did not state before me that she saw that accused fired to her husband when she was going on step. That is when at the very outset.
No, this her witnessing
Right.
the incident.
Right.
There is a doubt which you are trying to highlight.
My sub.
Highlight, and we may
Right.
also accept.
Right.
But so far as the dying declaration before PW1 is concerned,
Right.
that is not confronted. That
No,
is not
that-
contradicted.
No, contradicted by my lord PW.
Who?
Did
No,
not
here the
taking water.
contradiction will come from the IO. How do you contradict a
Right.
witness in the dock?
Right.
You can,
Right.
the defense has all the right to contradict by the statements given at the time of investigation.
Well,
Now
that-
she says that I saw him firing. That part may not be believable. But at the same time, he said to me in a very feeble kind of a voice that Atwar had fired, and the PW2 said that he pointed out.
Point.
So far as PW2 is concerned, question has come.
Right.
to the IO.
Right.
IO said, no, he did not state before me.
Before-
But there such a question did not come so far as PW1 is concerned regarding the dying declaration. So that remains intact.
by the eye,
No, yes, contradiction is can be only by the IO. Who else?
Right. but
If
other
you, if, you,
witnesses,
if you come to PW1 again, there is a clear dying declaration at page 8. Page 8.
right.
Page 8 it starts. You kindly come to page 9 before the cross, 7th line from the bottom. As soon as I got hold of my husband, he told me twice that Arthur had shot him.
Right.
Now this, if this was not said before the police in investigation, this would have been the first question would have put by the defense, not put. The court had put, but here there is no denial. That part is there. So if that part is there, immediately we'll have to come to section 32 of the Evidence Act.
Right.
Thirty-two one. No, the Evidence Act, the old one. Criminal Manual, section 32. Isn't that a criminal manual? What are you holding?
It is now
Or new one?
now.
New one will also have
But-
the same section.
same. Yes, it's in a part, by parts. It could be for whose attendance your total that's it's not when it's just when the statement is made by
As to the
case
cause of
the
his death.
death, or as any of the sets of the text which resulted in case which case of that death
Comes into question. Such
such
statements are relevant.
statements are relevant with what made them was or was at the time when the after exception expression of death and whatever may be the is the case of death comes. One would say of course better, but who that Nazrul Islam did not say
And come to PW2 also at page 47, the contradiction so far as PW2 is concerned. Read the entire paragraph. The second last paragraph, page 47.
page
Page 47. 47, we were reading the questions put by the court to the
Right.
IO. First, we have read, PW1 did not state before me that she saw the accused fired.
to
To her
her when
husband.
she was going
So this question has ended on the aspect of witnessing the firing.
Right.
There is no question regarding the dying declaration. That means there was the statement was already made. So there is no scope of any contradiction. But come to PW2.
PW did not state to me that he did not see Nazrul Ali from a distance of 60-70 meters, but he stated that he saw him from some
distance.
distance.
Okay.
He did not state before me that he had seen the accused when later came with the carbine in his hand.
Okay.
He did not state.
Thereafter.
He did not state before me that Mrs. Rosrul told his wife that Atwar killed him,
But
but
this witness
his
stated
witnesses
before me,
stated me that
this is pointed out towards the house of the victim. Pointing out there is no contradiction.
Moinul Haq did not state before me that he saw the accused along with carbine. He did not state before that this is told to them that they
See, question so far as PW3 is concerned, that question is put.
Right.
That did you tell before the police regarding the dying declaration? He said, no, I did not say.
but so far PW one is concerned.
One is intact,
Okay.
2 pointing out is intact. Then come to 848, did not state
He
before.
did not state before me that he saw blood stain in the
Don't say
front
did
of
not state it, did not state.
sorry, he
It
did not
doesn't
state.
look,
But,
it is incorrect and it doesn't look, doesn't hear good. PWA did not state before me that he saw blood stain in front of the house of the accused, but he said that he saw blood stain at PO.
He is but in front of the house. Formula PW 11 is concept. It's not a fact that PW did not state it, but I wrote the part. Now, 19 ballistic.
Hmm. 17 is the ballistic expert.
Expert.
Yes.
Well,
Let us read 17 before
but
lunch and we'll continue with this others. How did you read 17?
7.
Yes.
I joined as scientific assistant in 1979 at Directorate of Forensic Science, Kaitapara, after passing BSc in 1980. I was promoted to scientific assistant. In 1987, I was promoted as junior scientific officer. In 1995,
No,
I
leave this.
Well,
On 19/10/2012.
well, on 1910 to 12, I was working as scientific officer, FSL Caliper. On that day, I received a parcel through Director of SFL in connection with the Dhaliga base. The parcel consists of one carbon box enclosed with a seal cover. After opening the parcel, I found the article as 1 9mm calibre carbine machine gun registered number 16086-108 stroke 1995 marked as Exhibit A in the laboratory. 3 magazines loaded with 9mm carbine calibre Curtis marked as Exhibit B1, B2, B3 in the laboratory. 69 rounds of 9mm calibre Curtis, 59 numbers loaded in the 3 magazine and 10 numbers in the active packet, collectively marked as Exhibit C in the laboratory. 1 9mm calibre fired Curtis case marked as Exhibit D in the laboratory. 1 fire bullet of 9mm caliber marked as Exhibit D in the lab. After examination, I found the following result. Exhibit A is the 9mm caliber carbine machine gun and it is a factory gun. Exhibit A is found serviceable in its present condition. Exhibit B to 3 are magazine out for 9mm caliber carbine. Curtis. Exhibit B to 3 can be fitted with Exhibit A. Exhibit C are 9mm by 19 calibre live Curtis. Exhibit D is 9mm calibre fired Curtis. Exhibit A has been test fired in the laboratory. The test fire Curtis case of Exhibit A have been compared with Exhibit D, that is 9mm calibre. under comparison microscope, the firing pin impression of exhibit D and test fire cartilage case of exhibit A are found similar. Hence, it can be concluded that exhibit D was fired by exhibit A. Exhibit E is a 9 mm calibre fire bullet. Exhibit E has been compared with the test fire bullet of exhibit A. But due to some extraneous marks on exhibit E, opinion could not be found regarding its fire. To the court, if fire bullet hit any hard substance, then extraneous mark can be found on the fire.
See, what is relevant for us
Alert,
is the examination of the carbine which was seized along with the case, empty case and the fired bullet. So far as empty case is concerned, there is a clear opinion that the empty case was fired by the same carbine which was used, which was seized.
Exactly.
So far as the fired bullet is concerned, it was recovered. It could not be, definite conclusion could not be arrived because it
of
contained
the
extraneous marks. And he has explained that if it hits a hard substance after coming out of the target, then their extraneous marks are there. That has been explained. Relevance part is that whether this empty case belongs to that carbine from which it was fired. The opinion is positive.
But in that extent, the following in the cross, the following letter along with the box if by me is not submitted. I did not find extraneous marks on the anti-Curtis case exhibit. I do not know if exhibit E was not fired from the exhibit.
See, there cannot be extraneous marks on the empty case. Empty case falls from the carbine itself. It is the bullet. If it pierces through the object and hits any hard substance.
That is the product.
And he said to the quote, A, C, D, and E are of a 9 mm caliber. He has explained. Okay, we'll come back at 2 o'clock.
Right.
You try to make your defense on the dying declaration part.
Right.
What is the dying declaration? What is the evidentiary value? How is to be made? How is to be recorded? Okay. The Borbia, which matter? Probably may not be possible. After this, there is one more, I think, family matrimonial appeal. Yours is item number 11, may not
11.
reach
So, Lordship, pick the matter some other day.
some other day. You may not, because this is not complete. This is, we are yet to hear, madam.
Lord.
He is also yet to
Lord.
complete, okay?
May I have to be in the present or
No, not present. We'll give a date. Yes. Opinion we have read.
Right. It's 13, my lord.
Is there any materials on record that the carbine which was recovered was not allotted to you? We are just trying to find some avenues for you to argue because the matching has been done. These are circumstances which will form the complete chain. Even if we accept your submission that there is no eyewitness, PW1 cannot be treated as an eyewitness. In fact, in the other materials, that part of eyewitness there is some doubt. So let us give the benefit of doubt to you that there is no eyewitness. So the case will hinge over circumstantial evidence. So once it is circumstantial evidence, there is a requirement to have a chain complete. which leads to only one conclusion, that is the guilt of the accused and none else. So this is one of the circumstances, the examination by the forensic regarding the carbine and the empty shell and also the
Bullet.
used bullet. Used bullet, there is some doubt because it has got extraneous marks. He has also explained that it has heat a hard substance. But the shell, which was found from the place of occurrence, is corresponding to the shell, to the cartridges which were allotted to you in discharge of your duty. There was one cartridge shot. Out of 19 were found. And there are two other magazines containing 20 cartridges each. Those were found separately in the suitcase. But so far as the magazine which was attached to your carbine, one was shot. These are all circumstances which is forming a link. Now, is there anything on record to show that the carbine which was seized was not allotted to you? Because the carbine has got a number.
That is number.
The register has also been proved. The register by which the carbines are allotted to different constables or personnel on duty, it has got a incoming register, outgoing register. It was allotted to you.
It's, I have to say, it's not proof mallet. It is matter that overlapping mallet, the register mallet, register mallet. Just time that part mallet.
Yes.
Page 118 mallet.
118.
118. Material exhibit 10.
Yes.
Mallet. Truly honestly applies mallet. Your lordship. These are the correct proposals.
118. Yes.
118. This is the register.
Yes.
Perhaps in
Yes. Yes.
well, your lordship kindly see serial number second.
Second. Yes.
APCR. Carbon number 1608610.
Yes.
Now the carbon which was seized
Hmm.
is 1608610.
From where do you make this submission?
That is
Where?
what
108, where is the discrepancy which you are trying to highlight?
Right.
Where is the support? Which material?
in a 313 I have stated the carbon that was numbered issued not issued.
No, 313 is not evidence.
Well, that
You could have adduced defense evidence.
well,
No, who has proved this issue register?
that is
Was any foundation put to him in the defense that the carbine which was issued to me was not this number or this number? Was it put? Not put.
Correct.
There is no foundation. See,
Trial court.
when you defend a case
Well.
in a criminal trial,
well,
it is not mandatory to adduce defense evidence,
Well.
but to argue a particular point, you have to lay some foundation while cross-examining the witnesses. Put a suggestion to him.
Well.
Make out a case that from there you make the platform and you can argue. But if you have not made the platform,
well,
how can you argue?
only suggestion but page 23 mallet
23.
cross examination of PW 5.
Yes.
Last 6 line. In material exhibit 10,
Yes.
the body of the carbine is mentioned 6. There is overwriting on last number 6.
Yes.
In material exhibit 10, the countersign of the in-charge taken.
Hmm.
Only the person whom the arm and ammunition were issued to this.
Hmm.
It is not a fact that material exhibit was not exhibit means survived. It is not a fact that these items were not recovered from the course of the and it's not a fact that material exhibit 10 was subsequently manufactured. That the and this was
Let us again come to Material Exhibit 10. Page. You've just shown the page.
Page 118.
118.
118.
100.
Now let us see if there is any other carbine which number is almost similar. That 8 has been, see all, none of them are even near to your number. The nearest is second, number 3,
Third one.
third. 16086, 386.
Three.
Three numbers are different. It is not that the last number was different. And how do you overcome the aspect that one magazine was found, one cartridge was found short? Who found the carbine?
Alert, 5.
Huh?
5.
5.
5.
Please read.
Thereafter, police arrived, my lord, page 22, 7. During search, the place of birth, one empty case of 9mm ammunition and one fire were found at the place of occurrence. Police seized 9mm empty case at exhibit 2-1 is my signature. The fire bullet was
No,
also
the carbine.
and put my signature
The police also searched the quarter. Searched the quarter.
and found the 9mm carbine with one magazine fitted.
Because the IO in his deposition at page 45, no 46, that was found on the bed of the accused.
Ma'am.
Yes.
If you come to page 46,
Sir.
is there any corroboration or any contradiction that somebody has said that it was found from somewhere else? Come to page 46.
45.
Come 46.
46.
46. 46, from bottom, the second paragraph. When I reached the place of occurrence, have you found?
Yes.
I saw that there was a sign of firing
Firing
on
on
the
the
wall
wall.
in the corridor, which was a common place. I also
I-
found blood stain at the steps towards the house of the deceased Nazrul. I took several attempts to arrest the accused, but I could not find him. Material Exhibit 1 is the weapon used in commission of the offense, and I found it on the bed of the accused. So there is a clear statement that it was found on the bed. Is there any contradictory statement that the carbine was found from somewhere else? Because at page 22, this cannot be held to be a contradiction. He says that it was found from the quarter. So bed is in the quarter, so there is no contradiction.
It's rather specific.
No, somebody has said about some suitcase.
Suitcase.
Where? The rest were found in the suitcase. Huh?
Is the IO lordship. I see page number 45.
Yes.
I see one empty case of 9mm ammunition, one 9mm carbine, registration number so and so with one cylinder, one magazine, fitting with 19 round, 9mm ball ammunition, 2 nodes of 9mm carbine magazines loaded with 20 round 9mm ball ammunition in each magazine found in a VIP bag kept inside the room of the accused person, 10 round 9mm ball ammunition packing in a plastic carry bag which was kept inside the VIP bag, one old VIP bag size 18 inches Sony Company having name of the accused Atwar, one pellet, fired bullets 9 mm, empty cases and fired bullets were found in the corridor of the place of occurrence, and other find the accused because he fled away from committing the offense.
No, that is not the carbine. Ammunition, there are two other magazines which were given extra.
Right.
Those were found in the suitcase, VIP suitcase. And the one
Right.
where one cartridge was shot was found along with the
Right.
carbine.
Carbine.
See, let us read again. I seized one empty case of 9
Nine-
mm ammunition. This is the empty case of the fired bullet,
Fired
which
bullet.
was found in the place of occurrence.
Place of occurrence.
One 9 mm carbine bearing registration number
16086.
108. This is different. 6. Now, your lordship tell you this page 57, the register book. This is the number. Sorry, page 119. 11.
One zero six. There it is
Well,
108.
108.
Last
Last 108. Now it is
only the last.
only the last.
One digit is not matching.
Page it 119 and 45.
Madam, see the records. This is a type copy at 119.
Copy, yes.
See the record.
It's a fake copy.
Let us see.
Right.
Let us see.
It's
No.
it's
But
overnight.
No, it was 8, mid 6.
Yeah.
Great.
something there. Correct. The earlier one is also very light.
And this is also compared with the original. This is not the original. This is a
Not-
photocopy.
Correct. That report was final armor report was by
Has it come?
there is the order.
This code order is there.
It won't take it up. To say no.
That my friend
বারবার হেসে নিচ্ছে। এটা render করে।
We quoted 11/8/23.
Yes. True copy. True copy, again true copy.
Again, true.
True copy. Now original is not called for. True copy. True copy you already have. True copy. When were you arrested and from where are you arrested?
Well, I pray for bail matter and it was rejected. Then, as per honorable court order, I signed.
You prayed for anticipatory bail.
Well, that was,
Okay.
then
You were found absconding.
but since the apprehension of arrest, well,
No,
I,
you- no,
ac-
you- no,
well,
that is
well,
a fact.
accordingly, well,
That's a fact.
accordingly,
You
by
are
your,
found because
well,
your house, your door was knocked, you did not open. Ultimately, it was opened by your wife. And there is a suggestion that your wife had made a statement to the police that you went out through the back door.
Well.
Which your wife, on turning
Denied
hostile, has denied
that.
making such statement.
Well. It's but I signed it.
What is the motive, madam? Okay,
Well,
we come to you.
That is well, my illegal submission. Motive, take your lordship. Kindly consider this aspect. PW1 stated that there is no quarrel and on the day of the incident, the wife of the appellant also stated though there was a quarrel between husband and wife. That is the wife of the appellant and wife. No, assuming my lord, though it was not in the defense. But since there is no quarrel between there is no enmity between the parties, the deceased and the appellant. So in a 302, my lord, mainstay a motive with the vital code.
But motive is it essential if you have the knowledge? Motive may not be essential in all
But-
cases.
That is true, my lord.
Firing with a carbine in a vital part of the body.
That is since there is a if there been a marpit, my lord, I made a blow with one log or one step, then three made it, then motive is taken into consideration. Well, it is just maybe a malicious certain provocation, though of course, well, to be
That-
honest,
that is
it
not
is
even
not in
clear.
the defense matter. Have any reason, my lord, one shot is done and for that reason, it's the died. So motive, since they are reside in the same quarter, for that reason, my lord, repair. Depending on the judgment, it is repaired.
Which one? There are other cases also, recent cases,
But
that motive
you
may
like-
not be essential. Mens rea, of course, mens rea is the intention to kill.
Mal-
Motive,
That is there,
that
because he's knowingly
carbine hitting on a vital part of
Part-
the body and at a close range.
Close.
Carbine, the range is very high. It's not a small weapon.
But-
The distance would be hardly 5 feet, 2-3 meters. 10-15 feet, maybe. What are you trying to show, Mr. Hussain?
well, I'm not taking so much, my lord. Only just, my lord, handed over, my lord. Only, my lord,
Which one?
the criminal motive. Head notes, my lord,
No, which one? Which one?
page that, that is Kumar versus State of Representative by
2018. 2018.
2018 7 SCC 53.
Kumar.
I'm heading there. Head note.
Yes.
Motive effect on ocular testimony of witness, if any, held. Generally, in case of prosecution's desire to place motive of accused as a circumstance, like any other circumstances, it should also be fully established. If genesis of motives of occurrence is not proved, ocular testimony of witness as to occurrence could not be declared only on the ground of absence of. If otherwise, evidence is worthy of reliance. Murder trial herein, there is the absence of positive proof of motive and evidence of direct witnesses. is
You
not
read the consent paragraph.
my lord, 33 and 34.
33. Never read head notes. You also should read the part of the judgment.
But
But see the second part. But in the case on hand,
But
33. Towards the end, but the case in the case on hand, as we have already discussed in the above paragraphs, the evidence of direct witnesses is not satisfactory. And on the other hand, it is demonstrated that the deceased hit the accused on his head with a wooden log, besides the testimony from the eyewitness that there was a scuffle. In such situation, certainly motive may act as a double-edged sword. Hitting with a log
Well,
cannot be compared with a bullet being targeted on a vital part. And the weapon is a carbine. The bullet not only entered the body, it pierced through the body and hit the wall. No, at times, if it is a small weapon, the bullet remains inside the body. It has to be operated and taken out. It just passed through, went through. What is the other one?
my lord, so for the ballistic expert opinion is
Yes.
my lord, so that is 106 and 06 and 08. My lord, only one paragraph. 2019 6 SCC 535.
Paragraph?
Paragraph 18 and 19. The learned counsel appearing for the appellant mainly contended that fire bullet was not recovered and only empty cartridge made of a bronze were recovered near the mango tree. Contention of the appellant is that since the fire bullet was caused fatal injuries, the disease was not recovered. The ballistic expert cannot give definite opinion as to which weapon was used to cause the fatal gun wound to the deceased. The learned counsel further contend that ballistic expert has stated that he only tested the fire bullet C2 from rifle C1 and examined only empty bullet recovered. And therefore, from the evidence of the ballistic expert, it cannot be said that gunshot injury was caused the disease only from the rifle recovered from the rifle. Non-recovery of the bullet cannot be said to be fatal. Since the benefit of the doubt is given to the accused, the other aspect like darkness in the place of the occurrence and doubt as
No, this will go against you.
no, my lord.
This will go against you.
So my supposition
we are not inclined to consider the merits of the contention. And that was only the contention. The learned counsel for
not inclined. My lord, ballistic opinion cannot be, my lord, that ballistic opinion, my lord, so far the hitting of the bullet, the deceased, my lord, cannot be.
That contention was not even considered. We are not inclined to consider the merits of the contention assailing the opinion of the ballistic expert.
Correct.
This will not help you.
My lord, in my case, yes. since the opinion of the ballistic, but it cannot be said that the bullet,
No, you
because
show
of
some,
maybe reason extraneous.
you show some decision that the ballistic expert opinion cannot be relied upon. This is not a decision. Here, a contention was raised that the ballistic opinion cannot be relied upon. That was not answered, not required to be answered because there are other circumstances. See, just see, non-recovery of the bullet cannot be held to be fatal to the prosecution case against you. Since benefit of doubt is given to the accused on other aspects like darkness, those are other aspects.
But we are
May not
not
be.
inclined to consider the merit of the contention of assailing the opinion of the
Yes.
that is correct. So, from the evidence of the ballistic expert, it cannot be said that the bullet which was hit because of the extraneous
No, that
emerged from that
See,
carbine.
that we are not even considering. Even there is no specific opinion. He said that I cannot be specific because the used bullet
Yes.
had contained extraneous marks, and that has been explained.
Right.
That this bullet had hit a hard substance, and therefore there are extraneous marks. But so far as the empty shell is concerned, that has been there is a direct opinion that this shell appears to be from a bullet which is fired from this particular carbine.
Just I'm reading. I do
Yes.
not know if exhibit 1 was not fired from the exhibit A. Exhibit 1 is that the black
Bullet. We are not on the bullet part. We are on the empty shell. There are two
exhibit A.
from the place of occurrence. They have seized an empty shell, and from the wall where the bullet had hit after piercing through the body, that was also recovered. Both were compared with the carbine. So far as the bullet is concerned, there was an opinion that since the bullet had contained extraneous marks, it was not possible to give a definite opinion. But so far as the empty shell is concerned, there was a definite opinion. You come to the opinion part
Well,
at page 50.
exhibit 50 matter. Bottom
Page 50.
Page 50.
Page 50.
bottom exhibit E in the middle part. Exhibit E is a 9 mm calibre fire bullet.
Caliber.
Caliber.
Exhibit E has been compared with the test fired bullet of exhibit A, but due to some extraneous marks of the exhibit E, opinion cannot be formed regarding its. If the bullet hit any hard substance, then extraneous marks. Live cartridges from exhibit C have been consumed during the test firing of A. The forwarding letter along with the box of the receipt by me is that I did not find any extraneous mark empty cartridge. Yes.
See, Mr. Hussain, there are two comparisons made. One is the carbine, which was marked as exhibit A, correct? Carbine exhibit A. The exhibit D is the empty shell.
Right.
And exhibit E is the used bullet. Used bullet had hit a hard substance and therefore there were extraneous marks, no definite conclusion. Empty shell, there is a definite conclusion that it was concluded that exhibit D was fired by exhibit A at page 50. Have you got?
Well, hence it is can be concluded that exhibit D was fired by.
Yes, anything else?
That for the dying declares a lordship.
Yes. See, your endeavor should be to create certain doubt in our mind and that the link is not complete. We have accepted your submission that there is no eyewitness. PW1 cannot be treated as an eyewitness because in the cross-examination and by the narration of events, it may not be possible to someone in the third floor to see what is happening in the ground floor, in the stairs, that in the stairs. But she says that she immediately reached. That time, the husband was still alive. He had made dying declaration twice. Her version. Twice he uttered the name of your client. And one witness has also said that I could hear, but he was not very sure. But so far as pointing out to the door of the And he stays in the ground floor. That is not shaken.
Right.
The appellant is in the ground floor. At one side you are staying, and the other side Deepak Ray was staying, I think.
Harvinder,
Deepak was someone. Those parts are intact. So now to dislodge the dying declaration,
that,
you have to
only special bench regarding the criteria, the disease was not in a fit phase of a the point to declare.
no,
It has to be melon.
dying declaration. You are not in a state feast of. So what is the how is it made relevant? It is statutory provision. 32 says it will be relevant, even if the person is not there. See, unless you come to the dock and say something, it will not be evidence. But if a person has passed away and that relates to the cause of death, even his statement, the dying declaration, will be a relevant fact under the Evidence Act 32(1).
Well.
What is here? What is there in Lakshman?
Para 3 melon.
There are three.
The basic theory of the regarding acceptability of the dying declaration is that malad. This case after 3 constitutional, it is referred to the full bench constitutional bench. Just I mean last paragraph.
Yes. Paragraph?
Well, in the para 3 malad, just 2-3 lines.
Yes.
Para 3 malad, it is from the 15 line malad. The court also must further decide that disease was in a fit state of mind and had the opportunity to observe an identity of the assailant. Normally, therefore, the court, in order to satisfy whenever the disease was in a fit mental condition to make the dying declaration, looks up to the medical opinion. But where their eyewitnesses stated that disease was in a fit and conscious state to make the declaration, the medical opinion will not be prevailed, nor can it be said that since there is no certification of the doctor as to the fitness of the mind of the dying declarant, the dying declaration is not acceptable.
Acceptable. See, even certification is not required. And where is the question put in the cross-examination that he was not in a fit state of mind? You have to lay the foundational facts to build up an argument.
As submission method effect.
See, criminal trial, there is no pleadings as such. So where do you get the foundation from? Foundation you cannot argue. Nobody can say that there is no pleadings, so you cannot. You have to have the foundation from the materials on record.
Correct.
The evidence which has been adduced on behalf of the prosecution. You may choose not to give defense with evidence. That is fine. But you have not put the question in the cross-examination.
In fact, though it is not in the defense method, the reason for whatever instructed by the relative of the appellant, the reason for killing is some other reason. So it was not what it then suggestion.
That you cannot say. If you say
no, my lord,
the reason for killing,
no, my lord,
everything will be gone. Your entire efforts of killing
my lord,
will
that
be
is
gone.
just a at that time, court, honorable court has been the Honorable Court has the power, brother, to impose lesser punishment than the minimum punishment.
No, no,
Just-
what is the prescription of punishment? What is the offense involved? What is the statutory provision of punishment? 302.
Mala, that is
Can you
also
give any punishment which is not prescribed by the law? Cannot.
even 302 also can.
How can? How can you go against a statute? Either life or death. It is not up to or something like that. If it hasn't been up to, then yes.
Right.
But prescription of law is prescription of law. We cannot make the law. We can only interpret.
Let my learn.
Yes. If you had been able to make out a case that it is a case of 304 part or anything
No,
else, not 302.
302 part.
Okay, yes, madam.
Lordship, already Lordship have gone, so I will go to accused number PW1. Lordship, may I read from beginning?
Yes.
PW1, page number 8. The incident took place around 6:45 p.m. on 17/10/2012. At the time of the incident, my husband Nazrul Islam was posted at Kajolgaon. He worked in SB branch. We lived in a family quarter beside the SB office. We live on the 3rd floor. Accused Atwar lived on the ground floor of the same quarter. My husband used to come home in the evening every day, and just at that time, I used to come down and bring his shopping bag in advance. Now, on the day of the incident, also on seeing my husband stopping his motorbike, while she have seen Lordship, I came downstairs. Not after hearing the sound. She came while seeing her husband in the down parking the bike, motorbike. My learned friend have said that how could a person come immediately, but she didn't come after hearing the sound. She came by looking the bike, parking of the bike. I came downstairs. My husband was climbing upstairs and I was climbing down. She have already, Lordship, she have started coming downstairs, and husband started coming upstairs after parking the bike. Maybe 2-3 minutes have already taken after parking the bike. She have seen. Just then the accused Anwar came out with a carbine in the hand all of a sudden and stopped my husband from behind. He may see, Lord. It is not that she is from 3rd floor. I screamed as he shot. By looking at she shouted. I rushed to my husband. Then she rushed. And after holding him, I became unconscious. Accused Anwar ran to his quarter and closed the door. As soon as I got hold of my husband, he told me twice that Atwar had shot him. The bullet entered through my husband's back and exited through his chest. When I regained my conscience, I learned that my husband had died. So and so. But if there is dying declaration and that is there, Lordship, she came already. But it is not that after hearing the sound, she ran from the 3rd floor. And this is not contradicted. Nobody has said that you are on the 3rd floor. How could it be happen? That is Lordship PW1 and PW2. Now PW2. Lordship, I'll read the relevant portion, Lordship.
PW2.
PW2. Relevant portion.
Page?
Page 12, Lordship.
Yes.
It was about, from 3rd line, Lord. It was about 6:30 to 6:45 p.m. I was returning to the quarter after the duty hours. When I was about a distance of about 60-70 meters away from the quarter, I saw Nazrul Islam to get down from his bike. He parked the same in the corridor and thereafter proceed to the staircase for going to his quarter. He had a bag in his hand, which already his wife have said. Immediately after that, I saw accused Atwar to come out in the corridor with a carbine. That is corroborated with PW1 Lord, in his hand. After 2-3 seconds, I heard the sound of a firing. Immediately, I sat down on the road, but heard the scream of his wife, of Nazrul Islam. I rushed to the quarter. On going there, I found that the wife of Nazrul Islam had arrived there by this time, and she was holding Nazrul Islam. I saw the bullet injury at the back. He was alive till then. He asked for water. On questioning by his wife, Nazrul somehow managed to say the name of Atwar and also shown the door of the Atwar, pointing his finger. That is also IO have confronted Lordship that he have shown the door of the IO. So giving of water, and that is not their Lordship. But two things, Lordship, about the dying declaration and that PW2 so pointing his finger, Lordship. It is also said by the IO also. He was laying at the first stair near the quarter, or the door of Atwar was closed from inside. In the meantime, so and so. There was hue and cry, so and so woman. Thereafter we took the our in our department.
This sentence of PW2.
Lordship, he was alive.
No. He had a bag in his hand. Till that it is okay. See, he was at a distance of about 60 to 70 meters from the quarter.
Lord,
He saw Nazrul
Lordship,
get down from the bike, parking his bike. That is okay.
Lordship.
Now he was on the road. Immediately he had a bag. Immediately after that, I saw Atwar to come out in the corridor.
Lord,
Corridor means the corridor of the building.
building.
From the road, is it possible to see what is happening in the corridor?
First floor, Lordship.
Ground floor.
Ground floor.
Okay, but corridor, he is on the road. And see, why we are asking this question.
60,
After
70 meters.
2-3 seconds, I heard a sound of firing.
Lord.
See, he did not see the firing. He heard the sound. Immediately, I sat down on the road. That means he was still on the road at that point of time.
Distance is only 60, 70.
60, 70 meters is not a very small distance. 60 meters.
Meters, Lordship. 60
60.
meters. 1 meter,
Yes.
then Lordship 60 meters.
From that road, how do you see the corridor? What is going on? The quarters are not on the dead end of the road that you can see through the corridor. Quarters are either on the left or on the right.
Right.
Of the road. So if you are on the road, you cannot. It's not humanly possible to know what is inside the corridor
Lordship,
unless you reach in front of the quarter.
then Lordship, this is also there, Lordship, that he have pointed his finger. That is
No, thereafter he had.
Thereafter,
That's
yeah.
a different matter.
the,
He heard
he
the sound.
may not see that, Lord. Assuming he has just Lordship. But the thing is that after that he appeared there, and rest Lordship, his wife was there.
No, the problem is that once the exaggeration starts, it is difficult to regard a witness as trustworthy for the other aspects also. Witness cannot be truthful in one part and can maybe relied upon in other part. If he is a truthful witness,
In Lord.
trustworthiness
That is also there, Lordship, that about the eyewitness, Lordship. It's clear, Lordship, that she came, Lordship, while he have parked the vehicle. And that is corroborated with him that he also have seen parked the vehicle.
from third floor, yes, within 2-3 minutes, one can.
Come, Lordship, because now it is not everybody runs, Lordship, they said. Now itself, High Court, everybody runs, Lordship.
Okay. On the aspect of motive, what do you say?
Lordship, as most Lordship, motive may not be there, but he man's fear is there, Lord. By knowing, Lord, with a carbine one thought, Lordship, without knowing, everybody knows, Lord. by a firing. That's also in the place where one will not be alive.
Where is the actual, let us see the PM report.
PM report got it.
Page 36, the injury, a small wound
Postmortem
present
97.
on back of left side. Exit a wound from left to right.
Where where present in the right side of the chest over the right breast. Tear present in the upper part of the right pleural cavity, filled with blood. The backside of the left side size, but and the
Okay.
moreover he's trained as
Mhm.
he's in the police department. He's trained to use a firing gun. He's not a layman, Lord. Maybe a layman by cleaning a gun, that is some other issue, but knowingly, Lord.
Okay. Anything else?
But that's Lord. There are already eyewitnesses, Lord, and dying declaration is there. I think that's maybe happens.
One minute.
Yes.
Just on the one vernacular, the Sonali Begum, the infant. যোৱাকালি 17-10-2012 তাৰিখ ইংৰাজী সন্ধিয়া অনুমান 6:40-6:45 মান বজাত মোৰ স্বামী মটৰ চাইকেলেদি আহি মটৰ চাইকেলটো বিল্ডিঙৰ আগফালে থৈ গ্ৰাউণ্ড ফ্ল'ৰৰ কৰিডৰেদি চিৰি বগাই ওপৰলৈ উঠি অহাৰ সময়ত গুলী ফুটাৰ শব্দ এটা শুনা পাওঁ। মই সেই সময়ত মোৰ স্বামীৰ মটৰ চাইকেলৰ শব্দ শুনা পাই স্বামী আহা বুলি মই ছেকেণ্ড ফ্ল'ৰৰ কোৱাৰ্টাৰৰ বাৰাণ্ডাৰ পৰা ওলাই আহিছোঁ। গুলী ফুটাৰ শব্দটো শুনা পাই মই চিৰিৰ তললৈ গ্ৰাউণ্ড ফ্ল'ৰৰ কৰিডৰ পিনে নামি আহি অহাত দেখা পাওঁ যে মোৰ স্বামী আতাৰ আলী কোৱাৰ্টাৰৰ দৰজাৰ সন্মুখত চিৰিৰ তলত
We are reading
কৰিডৰত
161.
মাইল
161.
Right. জখমী অৱস্থাত পৰি আছে। So it is immediately on that same. So it is clear he was attacked. After hearing,
চাইকেল পাৰ্ক কৰা শব্দ শুনি মই ওলাই
that
No,
is
no,
true.
no, there is a contradiction. She has not said this before the police.
But গুলী এটা শব্দ শুনা পাওঁ। মই সেই সময়ত মোৰ স্বামীৰ মটৰ চাইকেলৰ শব্দ শুনা পাই স্বামী আহা বুলি মই ছেকেণ্ড ফ্ল'ৰৰ কোৱাৰ্টাৰৰ বাৰাণ্ডাৰ পৰা ওলাই আহিলো। গুলী ফুটাৰ শব্দটো শুনা পাই মই চিৰিৰ তললৈ
But
গ্ৰাউণ্ড ফ্ল'ৰত
Unfortunately, okay, appellate court still can
just time
compare, but if you have not put a question,
that
then
is
you have not stated before the police.
this
No, 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 there is, we stand corrected. Come to page 10.
in
Page 10. There is a denial, but it is okay, but 161, if you compare, fourth line. It is not a fact that I did not state before the police that while I was climbing down the stairs, I witnessed Atwar shooting my husband. Denial is there, but contradiction.
well, but while at having heard the
Hmm.
sound of the bullet, my lord, firing, my lord,
Hmm.
she came down. Thereafter, গুলি ফুটাৰ শব্দটো শুনা পাই মই চিৰিদি তলে গ্ৰাউণ্ড ফ্ল'ৰ কৰিডৰৰ পিনে নামি অহা দেখা পাওঁ যে মোৰ স্বামী আতাৰ আলী কোৱাৰ্টাৰৰ দৰ্জাৰ সন্মুখত চিৰিৰ তলত কৰিডৰত জখমী অৱস্থাত পৰি আছে। So she never seen that the accused did fire on the later on after, but my apples are not beyond the reasonable doubt, but
No, no, at best, that we have already indicated to you. The aspect of eyewitness, we have almost accepted your submission. It is that doesn't seem reasonable to accept her as an eyewitness. Okay, by A.K. Hussain, A. Begum, hearing concludes judgment is reserved. Okay.
I have a prayer, man, in respect of item 12, Lordship.
No, 12 will not take up.
Well,
Maybe there's one more criminal appeal,
well, well,
matrimonial appeal.
only
That probably will be the last
well,
case.
my may I pray,
We'll have another date.
my lord,
Yes, we'll give a date.
I love.
लिख दिया ना? Okay.
My lord, may I pray next?
No, no, so he'll give some date. There will be other cases also.
Then
What is this? Mr. Ghosh?
But
Hmm?